My name is San Diego-based criminal defense attorney, and today I'd like to discuss with you how a quality and experienced criminal defense attorney like myself will fight a drug charge if hired to represent you facing drug offenses. There's many different ways you could fight a drug case. From a preliminary motion standpoint, you could attack the reason for the initial police encounter, the reason for the search, the reason for the blood draw or the chemical analysis of the drugs, whatever. You can, from a preliminary hearing perspective, if the case is charged as a felony. A couple of examples. I've represented people, one person in particular, where they were pulled over. It was a legal stop, meaning there was a traffic infraction, which was legitimate. The client was pulled over. A conversation ensued. The police wanted to search my client's trunk. My client at no time gave consent to search the trunk. Law enforcement, based on what they knew at the time, did not have a legal right to get into the trunk. Nonetheless, they went in the trunk and they found 60 pounds of marijuana in a garbage bag. My client said to me, hey, I never consented for them to search the trunk. I said, good, because that's a real good issue that we have to fight the case. He was charged with possession for sale and transportation of marijuana. He was facing multiple felony charges and several years in prison. As a result of that case, his former attorney told him to take the deal. He hired me, we looked at everything, and I pressured basically, the prosecutor to a certain degree to say, hey, listen, wait a minute. I know this law enforcement agency has audio tapes, at the very least, a belt recorder of this encounter. And I know you haven't turned that over to the previous attorney. I'm not saying you guys have it, but I know the police have it. So if you could do me a favor and look in and get me those audio recordings, because I think that'll support my guy's story. Nonetheless, it didn't necessarily support it 100%, but what it did show was that at no time do you hear my client saying he gives consent for the search. So what happened is we fought and we fought and we fought, and on the day of the preliminary hearing, where the prosecutor would need to put on enough evidence for the case to go forward, I had also filed a motion to suppress evidence, basically saying, hey, they needed a warrant or his consent. They had neither. And the prosecutor wound up dismissing the case entirely. So that's an example where, had that search been deemed legitimate or lawful, we wouldn't have had a great defense to possession for sale or transportation of marijuana. But that entire case went away without having to worry about that because of the suppression issue that we raised through our work, and by being deliberate and by being efficient and effective with our negotiations with the prosecutor, they wound up ultimately dismissing the case. Another example would be a case if, even if you're charged with possession for sale of an offense, there are certain elements to that offense, one of which being that you actually had the intent at the time possessed, that it would be possessed for the purposes of sale. So just because you may have a lot of drugs on you doesn't mean, oh, that's it, okay, you're out of luck, let's try and get the best deal possible. It's amazing how many attorneys will go through a case and advise their clients to plead guilty to something after skimming through the discovery and the police reports without even looking at the jury instructions, without looking what needs to be proven in order for their client to be convicted at trial. So many times on drug offenses, people get overwhelmed with the amount of drugs. Oh, so it's got to be this, it's got to be that. Everything needs to be met. But, they don't really look at the elements of the offense. And when you look at the elements of the offense, sometimes it's difficult for the prosecution to prove each and every element beyond a reasonable doubt. So that's an example where you can kind of, use the system to your advantage, but you need to have the right attorney. You need to have the right set of facts as well. So, there's so many ways you could defend against a drug case, whether it's by way of a suppression motion, if it's a credibility contest between you and the arresting officer or the arresting agency, you could file something known as a pitches motion, trying to gain access to any complaints of dishonesty that officer has in his or her file or personnel file. There's preliminary motions. There's the option always to take the case to trial, particularly if you're not getting much, if any, of an offer from the prosecutor, and you won't be in much worse, if any worse, of a position even if you're convicted at trial. So there's so many things that can be done, particularly in drug offenses. The first step is, obviously, if you're contacted or arrested for a drug offense, keep your mouth closed. Don't corroborate or confirm anything. Don't confirm it's your drugs. Don't say anything other than, this is my name, this is my identifying information, and speak to my attorney politely, and, make sure you hire the right attorney. And there's a lot of things that can be done in these types of cases, whether it's fighting the case, trying to get a not guilty at trial, trying to get the case dismissed, or putting the prosecution in a position where, they know it's in their best interest and it's in everyone's best interest to negotiate a more favorable outcome than what you're charged with.